For starters, we can regard international law as law minus, as law from which one of its common characteristics has been subtracted. So we have said that law involves rules that govern behavior, that they are commonly rules laid down by an authority, and that they are enforced. Broadly speaking, international law is not enforced. There is, broadly speaking, no such thing as an international police that can ensure that international law gets applied. As a consequence, international law operates in a way that is blurry between law and ethics, or law and diplomacy. International law relies much more than other forms of law into its symbolic value, as opposed to the possibility that some sort of police system could be triggered to put it in application. Who then is the authority laying down international law? The first thing that we have to realize is that for international law, we do not have a centralized authority making the law. Although the UN's General Assembly has representatives for every country and has been called poetically the Parliament of Man, the UN is not a real parliament. The UN has no legislative powers. The making of international law falls back on states themselves, who by virtue of their sovereignty can also limit their sovereignty by entering into international agreements. That means that international law, to a large extent, feels like contract law. Treaties are very similar to contracts. It's a form of law where the main rules have been made by the parties themselves. So if the authority making international law is the states themselves by virtue of what they agree to, it is natural to say that the first source of international law is international treaties. Treaties are these agreements between states, and although there are subtle differences between contract and treaty, they are not identical, they are not the same. For our purposes, to get a quick grip on the idea of treaties, it's fine to say that treaties are agreements or contracts between states. Examples of treaties would include a bilateral investment treaty between two countries, for example, the 1995 BIT between US and Honduras, the United Nations Convention on the Law of the Sea that sets off rules regulating the commons of the ocean, the International Covenant on Civil and Political Rights, which is a treaty setting up human rights, and the UN Charter, which is a treaty that sets up the United Nations. And here you can see that treaties can both regulate conduct, as in the case of the Bilateral Investment Treaty and the Human Rights Treaty, but they can also set up organizations, like the UN Charter. This does not really distinguish treaties from contracts, because remember that contracts, the ones we studied in the book, were mostly about conduct and obligations, like a sales contract, but there are also contracts setting up corporations, clubs, NGOs, and other legal entities. So creating an organization does not necessarily take us away from the contractual paradigm. Now let's highlight some ways in which international treaties are similar and different to contracts. First, let's talk about similarity. International treaties are similar to contracts in that they're based on the consent of the parties. Just as in contract law, the autonomous individual must consent to be bound by a contract before he has any obligations. In international law, a sovereign state needs to consent to be bound by a treaty before it has obligations. This leads to a characteristic of international law that is called state voluntarism. State voluntarism simply says that the international law that exists because states will it to exist, that states cannot really be subject to international law against their will. But this is sort of obvious when we think about this idea that the authority is the states themselves, but when we talk about state voluntarism, what we really want to do is to highlight the deficiencies or the weaknesses of a system based on voluntarism as opposed to a system based on, for example, rule or majority rule, which is what you have in domestic law. Think about a common problem of the world, such as the environmental crisis. It could be the case that most states of the world, the great majority of the states of the world, want to have a stronger system of restriction of greenhouse gas emissions. But then let's say the main polluters, let's say China and the US, they do not want this. They see this as contrary to their economic interests. If this is the case, because the system is contractual in nature, there is nothing that the majority of the states can do to force China or the US to sign up to a treaty reducing greenhouse gas emissions. In fact, they're left with only two options. Either reduce their emissions themselves and allow the US and China to continue to pollute and also to get an economic advantage by being unconstrained by the environmental rule, or to simply reduce their ambitions to the point that they can get US and China on board. This leads to a dynamic in which it's true that international law, the caravan moves at the speed of the slowest wagon, because every state needs to consent to a rule. Under state voluntarism, you can never put rules that are stronger than what is desired by the least willing of the states. Naturally, it will be possible to leverage political pressure to try to make the US or China sign, but that would be a political solution as opposed to a legal one. Now let's move on to the differences. Contract law is always reciprocal. That means if there's a contract between one person A and another person B, and person A does not uphold his side of the bargain, then person B is under no obligation, at least in principle, to uphold by his side of the bargain. In other words, if A does not comply with the contract, B does not have to comply either. So for example, if A is renting a room from B and B fails to repair the heater, until B repairs the heater, A does not have an obligation to pay the rent. When it comes to states, there are situations in which this holds and situations when it does not hold. So here we have two countries, so now no longer people. Here we have two countries, country A and country B. And imagine the scenario here is simply one of trade. The countries agree to trade without tariffs. So A can send refrigerators to B and B does not put on a tariff, and B can send bananas to A and A does not put on a tariff. If it happens that B puts on a tariff and starts charging for the refrigerators higher taxes than were authorized by the treaty, then A is allowed to reciprocate and also stop his side of the bargain and put tariffs on the bananas. And in that way, you may find in a scenario where reciprocity holds. But not all international treaties are like that. And in not all international treaties does it really make sense to have a condition of reciprocity. Now the countries A and B have not signed a free trade treaty, but rather they have signed a human rights treaty. This treaty, amongst other things, prohibits torture. If it turns out that A is actually torturing its citizens, that does not mean that B can start torturing its citizens in turn as a pressure mechanism. So until you A stop torturing your citizens, I shall torture mine. That naturally does not make sense. That is patently absurd. In these scenarios, we say that international law creates a regime that is not reciprocal in character. Here, essentially, every state has to uphold its side of the bargain without paying attention to what the other party does. They simply have to do what the rule says. It's natural to interpret the absence of reciprocity as saying that treaties are stronger than contracts. This might be true from a legal perspective, but from a political perspective, it's actually the opposite. A system that does not have reciprocity is one that is weaker to one where reciprocity exists. I will explain this towards the end of this lecture when we see the theory of Andrew Guzman about how international law works. Alongside treaty law, international law always recognizes customary law. Customary law can be defined as settled expectations that have legal significance. What has been traditionally done when the conditions for customary law apply becomes a binding rule. Traditionally, the conditions for customary law are described in two components: state practice and opinio juris. State practice refers to the idea that for something to be a custom, it must be something that's respected, honored in the behavior of states across geography and time. Opinio juris is what allows us to differentiate customary law from a mere custom. Opinio juris refers to the idea that when states behave repeatedly in the manner in which they're supposed to behave, they do so out of the conviction that this is legally required, as opposed to some other idea, for example, diplomatic nicety or generosity. Then, for example, something that is customary law would be the prohibition of torture. States honor the idea of prohibition of torture repeatedly and also do so with the conviction that this is a requirement that is, as a matter of fact, legal in its nature. By contrary, overseas development assistance, or ODA, is not customary. Although all countries or most developed countries give funds of ODA in a yearly basis, so there's repeated behavior, they always insist that ODA is not a right, that it's not something that's legally binding in nature, that simply out of generosity, they choose to give ODA. Notice in this example that I mentioned as an example of a customary rule, the prohibition of torture. And if you paid attention in the prior slides, you would have seen that human rights treaties, of course, also prohibit torture. Naturally, that is not a problem. The same rule can be legislated by different sources. The prohibition of torture in this scenario is legislated both by a treaty, the red circle, and by custom, the blue circle. So essentially we have two sources defining and enshrining the same rule. It's good to go back now to the claim that the authority of international law is the will of the sovereign states, because at first glance, custom might not fit that picture. As a repeated pattern of behavior, you could say, well, custom does not really have an origin in the will of states. Well, the idea is that it does. That custom is something like a quasi-contract or a quasi-agreement, or to put it more simply, a tacit agreement. When a customary rule arises, the idea is that the state community just comes to accept this rule as binding upon them in an informal manner by repeatedly complying with the rule and by forming the opinion that the rule is required without ever writing it down explicitly in a contractual manner. The idea that custom is quasi-contractual in nature is something that becomes manifest in the persistent objector doctrine. This is the idea that when a new customary rule is formed, a state may say, I do not wish to be part of this, and explicitly object to the rising rule. So imagine there would be a shift in the attitude of states to overseas development assistance, that big EU donors would start to say that they recognize that giving ODA is a form of, is a right, that giving ODA is a part of what is required by them under the United Nations system, human rights, and the right to development. A state, let's say the United States, could say, I object to this idea that ODA is an obligation. I emphasize that for me, ODA is something that I give merely out of generosity and that I can suspend whenever I so wish. Under this characterization, the US would be able to exit the emergent customary rule, and the customary rule would hold for states, but not for the US. In this manner, we go back to the image that I gave earlier of the caravan moving at the speed of the slowest wagon. We are back in the territory of state voluntarism. Now let me say something brief about jus cogens, and for jus cogens it's fine to be brief because the practical importance of jus cogens is extremely limited. So we went back to this analogy with contract law. For most purposes, international law functions like contract law. The rules are the rules that the parties themselves agree to. In contract law, there's limits to the contracting power of individuals. I cannot purchase a homicide. I cannot purchase cocaine. In some jurisdictions, I might not be able to gamble. So these would be public order exceptions, often called mandatory rules, public order exceptions to the freedom of contract. In international law, it's theorized that the same thing exists, that there is a form of rule called jus cogens that lies at the bottom of the international system and that sets a limit to what states can choose to agree to. So if one state over here and one state over here makes a contract to invade this country in the middle and to split it, so that's the treaty, I will invade on this side, I will invade on this side, and I will enslave the population of this country that is here, and I will enslave the population that is here. Naturally, we would want to say that that treaty is invalid through the operation of jus cogens. Jus cogens would limit the operation of this treaty, which is not just the autonomy of the states, but you cannot use that autonomy in breach of the most fundamental principles of the international order. This treaty would be invalid. Now, the reason why I say that jus cogens has very limited practical significance is that because this seems to be very important and very powerful, and to a very large extent, and to some extent it is, but in practice, jus cogens is not very significant because the threshold of things that breach jus cogens is so low that it would be very difficult to imagine a situation outside total war in which jus cogens would have a practical impact. So the provisions that are generally recognized to be jus cogens include genocide, torture, the prohibition of slavery, and possibly war of aggression. And you can see that with these four prohibitions, you do have a limit to the contracting authority of states, but that the threshold is a very low one. We're talking about really horrible, absolutely barbaric behaviors. We're not talking about what would be more of a polemical nature. Now let's say something about enforcement of international law. International law famously has very weak enforcement powers. Essentially, there's two ways in which international law can be enforced. This is collective enforcement and individual enforcement. Individual enforcement should be the exception and not the rule. So if one state A and another state B have a fight, and State A claims that the rules of international law have been breached. Normally, you would not want the State A to take things into its own hands and try to enforce international law, for example, by invading a State B. That, if you can imagine, would be extremely dangerous and would lead to the creation of war, conflict, and significant suffering. For that reason, the idea is that except under situations of self-defense, international law needs to be enforced collectively. The United Nations Security Council is the only entity that has the authorization to enforce international law in this collective mechanism. By triggering the Security Council, states can form coalitions where they can deploy military force to enforce international law. But enforcement through the Security Council is rare. The main reason for this is that the Security Council operates with a system of 15 countries, 5 of which are the P5 permanent members of the Security Council. These permanent members hold veto powers, which means that if a decision is going to be taken with which they disagree, any one of these P5 members, US, UK, France, Russia, and China, can veto the decision and end in a situation of inaction. So collective enforcement through the UN Security Council is rare. This is probably for the better, as the Security Council has been designed to minimize the chances of a significant East-West war by ensuring that for every armed intervention, all the big nuclear powers are on the same side. The UN Security Council tries to avoid the worst outcome of having a conflict between the Eastern and Western blocs. But the price to pay for that is that it's the enforceability, the collective enforceability of international law is very limited. But there are other forms of enforceability that may work in some scenarios beyond, let's say, individual enforcement by aggressive means or collective enforcement, which is under lock and key. And here we do well to go to the thesis of Andrew Guzman. The work of Andrew Guzman is a work that explains international law in a rational choice paradigm or an economic decision-making paradigm. And then he says you would have 3 situations in which international law is going to be effective in spite of the absence of individual aggressive enforcement, in spite of the absence of collective enforcement. These refer to situations where reputation, reciprocity, or retaliation are available. The idea of reputation simply says that states have an interest, a selfish interest, in having a good reputation as respecters of international law. The reason for this is that states that have a bad reputation in breaching international law will only be able to enter into international agreements at a higher price. If I am bargaining with a state and I know that his willingness to comply is very high, then I will more easily enter into an agreement with that state. If I am bargaining with a state and I know that that state very often breaks the rule, I will not want to enter into an agreement with that state unless the agreement is especially generous in my favor. By this idea, think for an analogy, think about going to the bank or petitioning for a loan. If your credit record is AAA, the bank will give you a loan more easily and will give you a loan with lower interest rate. If your credit record is C, the bank will not want to give you a loan unless it puts a very high interest rate. Then with this idea, you can see that the states may have, just for selfish reasons, an interest in keeping their reputation as compliers of international law in a good level. The idea of reciprocity is one that we already explored. Reciprocity means that if you don't do your side of the bargain, I do not do mine. Then a way to enforce international law is simply this. If you have a treaty between countries A and B, and that is a treaty from which both countries benefit, for example, this free trade treaty, you start to break your treaty, you put tariffs on my refrigerators, then I can pressure you to comply by putting tariffs on the bananas. In this way, by withholding my side of the bargain, I can create pressure on you to do your side of the bargain. Retaliation simply refers to my ability to punish you in some other way than just simply withdrawing my side of the bargain. And we have seen that individual conflict resolution is naturally disencouraged by international law, but that goes for aggressive war. There could be other forms of retaliation with which a state could unilaterally hurt a non-complying state that do not imply the aggressive use of force. And then, for example, I may credibly be able to punish a non-compliant state by disrespecting its intellectual property. Then if you do not comply with the trade treaty, if you raise tariffs where they shouldn't have been raised, it might be possible for a state to say, okay, we will disrespect the rights of the patent holders. This is actually a little bit more polemical because international law will still curtail the possibility of these forms of retaliation. Reciprocity, for example, can almost always be taken out if the treaty is reciprocal in nature. Retaliation is a little bit more complicated, but it's certainly one other possibility, one more tool in the toolbox. Using Guzman's theory, we can come up with the concept that international law has an envelope where its enforceability is pretty good. So here we have two states, just normal states. We could call them Honduras and Guatemala, states roughly of the same size, roughly of the same characteristics. Then they make trade agreements. You could say that in general, a lot of those trade agreements will be easy to enforce. These countries have an interest in having a good reputation in order to keep negotiating agreements in the future. If one of them does not comply with its side of the bargain, the other one can naturally withhold its side of the bargain, and potentially there could be forms of retaliation that could be taken. For example, if a lot of students travel from Guatemala to study in Honduras, it may be that if a treaty is not complied with, one of the countries can make it harder for the students to get visas. So here we have a very, that is to say, here we are within an envelope where international law will quite normally work. But if we change the paradigm a little bit, if we change the situation a little bit, and now instead of having this interaction between Honduras and Guatemala, we have an interaction between the United States and Guatemala, things become very different. As you can see, Guatemala has an interest in having a good reputation in order to get into agreements with the United States. But the same thing is not true of America. America might feel that it has little to lose by not entering into agreements with Guatemala. In terms of reciprocity, if there is a trade agreement between them and the US raises its tariffs illegally, Guatemala may say, well, if I raise my tariffs, that's going to hurt me more than it hurts America. Because I depend so much on American imports that if I raise my tariffs, I am going to essentially shoot myself in the foot. And then the asymmetry of power between these countries is so large that there may be very few valid means of retaliation that Guatemala could use against the United States, and possibly there could be none. So this tells us that international law, the ideas of Guzman would say that international law may have this being one of the more moral or diplomatic areas of law, because of its weak enforceability, but you may still say that it has some enforceability within a certain envelope when countries are of a relative equality and have a mutual interest in having good and strong relations. When that envelope is broken, when you have, let's say, on the one side a very small state and on the other side a superpower, international law becomes much more of a moral and a diplomatic principle as opposed to a strictly legal system.